TikTok just came out swinging against the federal government. Both the company and 8 U.S.-based TikTok creators filed their opening briefs with the U.S. Court of Appeals in Washington, D.C. today. They are asking the court to step in and rule that the Protecting Americans Against Foreign Adversary-Controlled Applications Act, overwhelmingly passed by Congress and signed into law by President Biden, is unconstitutional. They want the law, which forces ByteDance to either sell its interest in U.S.-based TikTok or face a ban on January 19th, 2025, stopped now. In TikTok's 99-page brief, yes, I read the whole thing, TikTok gives a laundry list of laws they say Congress crossed with this piece of legislation. They say, never before has Congress silenced so much speech in a single act. Congress reached for a sledgehammer without even considering if a scalpel would suffice. Now, before I get into all of this, if you want to read the actual briefs and all the never-before disclosed documents that TikTok attached, I will email them all out to you tonight in my Newsgirl News Roundup email, so make sure you sign yourself up. Okay, in TikTok's brief today, TikTok says this law is a flagrant violation of the First Amendment, not only of the free speech rights of the 170 million U.S. users, but also a First Amendment violation because Congress is treating TikTok differently than any other foreign adversary-controlled application, which they say is an equal protections violation. Lawmakers who support this law said TikTok was a national security threat because it could be used as a propaganda tool of the Chinese Communist Party because of its Chinese-based parent company, ByteDance. TikTok's brief says that's ridiculous for several reasons. One, they say it's absurd because of the $2 billion Project Texas security system on U.S. soil, which puts up a firewall to protect U.S. user data. And two, even if foreign propaganda was somehow on the platform, the Supreme Court ruled in the 1965 Lamont case that foreign propaganda is still considered protected speech under the First Amendment. TikTok's brief says, Congress asserts the power to control the information Americans can receive, whether it originates abroad or within the United States, a clearly improper purpose. Congress, thus, has no legitimate interest in insulating Americans from divisive narratives, whether or not that is called propaganda. Policing disinformation and misinformation is no less suspect, subject to narrow, well-established exceptions, not applicable here. Speech does not lose First Amendment protection because the government deems it untrue. TikTok also argues this law is a violation of Article 1 of the Constitution, the Bill of Attainder Clause, which states that Congress cannot single out a specific person or group with legislative punishment. Now, if you look at the actual law, yes, the title says foreign adversary-controlled applications, which is a broad group. But if you look at the text of the law, it singles out TikTok and ByteDance several times. The brief also says the law is a violation of the Fifth Amendment's so-called takings clause, which says the U.S. government cannot take private property for public use without proper compensation. TikTok's brief goes on to say this law is wild with speculation, but scarce on the facts. They argue that lawmakers who supported this bill gave multiple reasons why it was necessary, but never showed any actual proof of any national security threat. They say lawmakers ignored the years of work that TikTok did with the U.S. government to come up with a solution to these lawmakers' concerns. In fact, for the first time ever, TikTok has disclosed the actual national security agreement they worked on with the Biden administration, an agreement the Biden administration walked away from, saying it wasn't good enough. The brief argues this law sets a dangerous precedent, allowing the political branches to target a disfavored speech platform and force it to sell or be shut down. The Constitution does not allow Congress to single out one speech platform, make no findings, announce no justifications, ignore less restrictive alternatives, and discriminate based on speaker and content. Next month, we will get a response brief from the U.S. government, which will give all the reasons why the government says this law is constitutional and the courts should stay out of it. Then we will hear oral arguments in the Washington, D.C. Appeals Court on this case on September 16th.